Haji, next is S.R. Bommai versus Union of India 1994. This is a landmark case. The question arose in the court was whether the center imposed president rule arbitrarily. Whether can the center government impose president's rule or the constitutional emergency on a particular state? We have many states. So can that president's rule be imposed by the president arbitrarily? Because in the history of India, constitutional history of India, legal history of India, this president's rule was misused many times. It was imposed arbitrarily many times by the central government, mostly by the Congress government, Congress High government. If we see the history of Indian constitutional history. So, can this question arose in the Supreme Court? Can the central government impose the president's rule under Article 356 arbitrarily? Arbitrarily means without fair procedure. Without fair procedure. Basically, what is the ground for the imposition of president's rule on a particular state? It is if the state or a particular state does not work according to the constitution or the constitutional provisions. If the state does not work according to the constitutional provisions, for example, there is a constitutional provision, Article 365, which says that the state has to adhere to the directions given by the center. The state has to adhere by the directions given to it by the center. This is given under Article 365. And if the state does not consider these directions worth of observing, or if the state does not take into consideration all the directions or orders given by the center under Article 365, it means the state is not working according to the constitutional provisions. And if the state is not working according to the constitutional provisions, under Article 356, constitutional emergency can be imposed on that particular state. That is, the president's rule can be imposed on that particular state. Is it clear? So, whether that constitutional emergency or the president rule can be imposed on that particular state besides this reason given by the constitution itself. What is the main reason for that? The main reason is if the state is not working according to the constitutional provisions. Besides those reasons, besides this main reason, is there any other reason on behalf of which the state emergency can be imposed? There seems to be no other reason. But in the history of Indian constitutional history, we have seen many times that this emergency rule was imposed, that is misused by the central government on those states which were having the governments which were totally opposite to the government at the center. The center was at that time ruled by the Congress High government, and in most of the states in which the government was not Congress government, it was some Janata Dal government or some other government. So usually the center imposed constitutional emergency or president rule on that particular state just because of different ideology. You see, that is misuse. That is misuse. So in S.R. Bommai, the Supreme Court said, no, this can't be done again and again because this is totally misuse of powers. In case president's rule has to be applied, certain constitutions has to be taken into account, and one of the constitutions is that the state is definitely not working according to the constitutional provisions. If the state is working according to the constitutional provisions, then very rarely president's rule must be imposed on that particular state. Actually, what happened in S.R. Bommai case? S.R. Bommai was CM of Karnataka. CM of Karnataka. He was the Chief Minister of Karnataka. Some of the MLAs defected. Some of his MLAs defected. They went to some other opposition party. So he was in minority. You see, to have a government in the particular state assembly, you have to be in majority. more than 50%. Some of his MLAs defected, and he seemed to be in minority. And it went to the governor. The thing went to the governor, and governor told the president. Governor, who is the head of the state, he told the president. President is the head of India, head of the Indian state. So governor told the president that the state government has lost the majority. So it was the governor who decided that the state government, headed by CM Karnataka, SR Bommai, it lost its majority. So president's rules must be imposed on that particular state of Karnataka. So it was a governor's decision. Actual floor test was not there. Actual floor test was not conducted in the Karnataka Assembly, but this was the rule. Actual floor test must be conducted in the Karnataka Assembly. So what the Supreme Court said? Supreme Court gave certain guidelines. What guidelines were there? First is that if the government of particular state, like here of Karnataka, loses majority, it is the floor of the house on which the majority must be tested. It is the floor of the house on which the majority must be tested. Straightway, governor cannot go to the president and say that impose president's rule on that particular state because I am saying this thing. Because I feel that the particular state is not working according to the constitution because the government of the state has lost the majority. I feel this thing. No, it's not the feelings of the governor. Actual floor test has to be conducted by the governor on that particular state assembly. That was not conducted. Second guideline was, it is not only the governor's report that matters. Though governor's report does matter, but it is not only the governor's report that matter. Actual floor test must be there, and based on that floor test, if again the government loses majority, then the governor can report this to the president, and president can impose the president's rule. Then third is, president's satisfaction. You see, if the president feels satisfied that really the governor's report is worth considering and whatever the governor is saying is true, and the government of the particular state, here Karnataka state, is losing majority, and the government of that particular state is not able to handle that state according to the constitutional directions, they are not observing the constitutional directions as per given by Article 365, or whatever observations the president thinks are relevant for the imposition of president's rule, that personal observation of the president make him satisfied that this is the real or actual case of implementation of the president's rule. It's not the personal satisfaction of the president. That satisfaction must be based on some reasonable grounds. It is not the personal satisfaction of the president. That satisfaction of the president should be based on the reasonable evidence or grounds. And what is the evidence, reasonable evidence here? The actual floor test. Actual floor test, which was not conducted in the state assembly by the speaker of that Karnataka state assembly. So this was the lacuna in this case. These were the guidelines which were issued by the Supreme Court. And even the satisfaction of the president, if the president really feels satisfied that this is the fit case for imposition of president's rule or constitutional emergency, then also it is subject to judicial review. It is subject to judicial review. Judicial review by whom? By Supreme Court. Judicial review by Supreme Court. Even Supreme Court has the ultimate power. Here the Supreme Court has the ultimate power to see whether the satisfaction of the president, that is to impose the president's rule on a particular state, is that satisfaction legal or personal. It should not be personal satisfaction. It should be satisfaction based on some legal ground or legal evidence. Here it was lacking. Here in this case, it was lacking because the governor or the speaker didn't held floor test on the particular Karnataka Assembly. Is it clear? So all these guidelines were issued in SR Bommai case. It's a very, very landmark case as far as President's rule is concerned. And so in this case, Article 356 that is constitutional emergency or the President's rule. It was held that it should not be misused and it should be used only in genuine cases. Which genuine cases? In those cases in which the state government is really not working according to the provisions of the constitution. Just because the state government is having different ideology or different party than the government at the center, it is not a good case for the imposition of the president. That is misuse. That is misuse. Is it clear? So frequent dismissal जो हो रही थी उनको रोका गया और एसआर बमई केस के बाद बहुत मुश्किल हो गया स्टेट इमरजेंसी लगाना. अब कौन सा लग रहा है? इमरजेंसी लगी है, बहुत मुश्किल है. ठीक है, तो हाँ बहुत ही ज़्यादा लॉ एंड ऑर्डर की प्रॉब्लम आ जाए, फिर जैसे मणिपुर में वो हो गया था तो वहाँ जरूर लग गई थी. ठीक है, और जम्मू कश्मीर में तो चलो आर्टिकल 3 वो तो बिल्कुल स्क्रैप ही हो गया था. जहाँ बिल्कुल लॉ एंड ऑर्डर की प्रॉब्लम आ जाए, बिल्कुल ख़त्म ही हो जाएगा, है ना, वायलेंस स्ट्रीट्स में लोग वायलेंस पे उतर जाए, है ना, तो वहाँ जरूर इमरजेंसी लग जाएगी. लेकिन ये सब हुआ एसआर बमई केस के बाद. अब मिसयूज नहीं होता, चाहे कांग्रेस की सरकार हो सेंटर में, चाहे बीजेपी या किसी और की, मिसयूज अब नहीं होता एज कंपेयर टू अर्लियर. इट वाज ओनली बिकॉज ऑफ दिस लैंडमार्क जजमेंट ऑफ एसआर बमई वर्सेस कि कॉन्स्टिट्यूशनल इमरजेंसी को मिसयूज नहीं करना. क्लियर होगी कि नहीं? ओके.